In real estate, few topics demand as much ethical sensitivity and statutory precision as the acceptance of compensation and representation of more than one party in the same transaction. This final section brings together the principles discussed throughout the module: conflicts of interest, financial disclosure, and fiduciary duties, and applies them to one of the most complex areas of agency practice under Arizona law. Arizona real estate licensees are governed by ARS Section 3221553A3 and Commissioner's Rule R42811101, both of which require honesty, full disclosure, and fair dealing in every transaction. Specifically, R4-28-1101F provides that a licensee shall not accept compensation from more than one party to a transaction without the prior written consent of all parties involved. This rule exists to prevent divided loyalties and undisclosed self-interest, ensuring that the client's trust in their agent is not compromised by undisclosed financial gain. To fully understand this obligation, it is essential to distinguish between compensation, representation, and consent. Compensation refers to any payment, fee, commission, rebate, or benefit, direct or indirect, received by a licensee. Representation involves the fiduciary relationship, in which a licensee acts on behalf of a client. Consent is the client's informed and written authorization, acknowledging the licensee's role, relationships, and compensation sources. For example, imagine a listing broker who agrees to represent a seller but also finds the buyer for that same property. This situation creates limited representation, commonly referred to as dual agency under Arizona law. A licensee may represent both buyer and seller only if both parties give informed written consent through the Consent to Limited Representation form, approved by the Arizona Department of Real Estate, ADRE. Without this written consent, dual representation constitutes an undisclosed conflict of interest and violates R4-28-1101F and ARS Section 32-2153A3, exposing the licensee and their broker to disciplinary action. The purpose of this consent requirement is to ensure that both parties fully understand the limitations placed on the licensee's duties. In a dual representation, the licensee cannot advocate exclusively for one party, disclose confidential information without permission, or provide advice that favors one side over the other. The role becomes more of a neutral facilitator. Focused on completing the transaction fairly and lawfully, courts have consistently upheld the need for transparency in these situations. In the landmark case, Standard Chartered PLC versus Price Waterhouse, 1993, the Arizona Supreme Court reaffirmed that a fiduciary must act with absolute candor and full disclosure whenever potential conflicts or divided loyalties exist. The same principles apply when a licensee receives payment from a third party involved in the transaction. For instance, if a builder offers a selling agent a bonus for closing a property, the agent must disclose this additional compensation in writing to their buyer client before closing. This rule also applies to referral fees received from lenders, inspectors, or other service providers. Failure to disclose such payments may constitute a violation of RESPA Section 8A at the federal level and ARS Section 32-2153A3 at the state level. Consider a practical scenario. A buyer's agent shows homes in a new subdivision, where the builder offers an incentive bonus of $5,000 to agents who sell a home before a certain date. If the buyer's agent accepts or even anticipates accepting that bonus, it must be disclosed to the buyer in writing prior to executing the contract. Without disclosure, the buyer may later claim that the agent's recommendation was motivated by personal gain rather than the buyer's best interest. The ADRE has disciplined agents for exactly this kind of omission, as it erodes consumer trust and violates the standard of professional conduct expected under R4-28-1101A. Similarly, when a broker or licensee is compensated by both buyer and seller, such as in a lease transaction or land sale, the arrangement is only lawful if both parties consent in writing before the compensation is earned. The disclosure must clearly describe who is paying, the amount or nature of the payment, and the fact that no party is obligated to proceed without understanding the arrangement. This principle also applies when a licensee has an ownership interest in a transaction's outcome. For example, if a listing broker owns a partial interest in the property being sold, the broker cannot receive both commission and seller profits unless the interest is fully disclosed to the buyer in writing and approved by all parties. Even when the compensation or interest seems minor, non-disclosure violates the duty of honesty and can lead to sanctions such as license suspension or revocation. In practice, best conduct involves following 3 guiding steps. First, disclose early, before any contract is signed or money changes hands. Second, document the disclosure in writing and obtain all required signatures. Third, retain all documentation in the broker's file for a minimum of 5 years, as required by ARS Section 322.151.01. These steps protect both the client and the licensee by demonstrating transparency and compliance. Review summary. A licensee must never accept compensation from more than one party without the prior written consent of all parties to the transaction. When representing multiple parties, informed written consent is mandatory. Through the ADRE's Consent to Limited Representation form, licensees must disclose any additional compensation, bonuses, or referral fees from third parties before closing, ensuring full transparency and compliance with R4-28-1101E and R4-28-1101F. The guiding principle is clear. Clients must always know who is paying the licensee, how much, and for what purpose. Transparency prevents misunderstandings, maintains integrity, and fulfills the fiduciary duty of loyalty. Discussion. Why does Arizona law require written consent before accepting compensation from multiple parties? Answer. To prevent divided loyalty, ensure informed consent, and maintain transparency under R4-28-1101F. What must a licensee disclose if they expect to receive a builder bonus or third-party incentive? Answer. The amount, source, and timing of the compensation must be disclosed to the client in writing before contract execution. Why is informed written consent necessary in dual representation? Answer. Because the licensee's fiduciary duties to both parties are limited, and both must understand the implications before proceeding, as required by ARS Section 32-2153A3. Closing remarks. Professional conduct in real estate is measured not only by the results achieved, but by the transparency and integrity shown along the way. Accepting compensation from multiple sources or representing more than one party is not inherently unethical. Only undisclosed dual interests create problems. Arizona's disclosure and consent rules are designed to ensure that clients are never misled and that licensees act with unwavering honesty. The key to maintaining trust is clear documentation, timely disclosure, and adherence to the highest standards of ethical practice. When in doubt, disclose it. Because honesty is not just good ethics, it is Arizona law.